Morning.
Good morning.
Morning, everybody.
How are you?
Well,
Good.
I'm just gonna give it like another minute or two to see if we have anybody else joining, and then we'll go ahead and get started.
okay.
Good morning, everyone. Thank you for joining day 3 of our Tenant Training 101 curriculum. Today's presentation is on fair housing law and reasonable accommodations for case managers. This is an overview of various federal and state laws that require housing providers to make for reasonable accommodations and reasonable modifications, specifically for individuals with disabilities. We are joined today by Lakeisha Vaughn from the Department of Housing and Community Development and David Prater from Disability Rights Maryland. Just a little bit of housekeeping. Everyone is currently muted. So if you have a question specific to the training, go ahead and put that in the Q&A, and we'll try to answer those throughout the session. If it's a overall question, we'll take those at the end. We'll have a moment for questions and answers at the end of the presentation. This presentation is being recorded. It will be uploaded to MDOD's YouTube channel for viewing, and participants who are on the call today that have registered for the call, you will be provided with a copy of the PowerPoint presentation at the end of this session, along with a survey from SurveyMonkey, which you need to answer in order to receive credit for participating in all the trainings, to be able to move on to do the shadowing at the end of day 4. So I'm not sure if you guys need me to put up the PowerPoint, or if you, I already have it ready to go. So if you just want me to go ahead and start it, I will do that. All right.
I think that would be great.
Okay. All right. Let's get started. All right. Ready to go. Welcome, Lakeisha and David. Thank you for joining us today. We're ready when you are.
Okay, great. Well, I don't think Lakeisha and I have rehearsed this, but I'll go ahead and jump in. My name is David Prater. I'm a managing attorney at Disability Rights Maryland. Can we go to the next slide? And we're going to be so Disability Rights Maryland, along with there we go. Disability Rights Maryland is the designated protection and advocacy agency for the state of Maryland. Just a little bit of background about what Protection Advocacy Agency is, or a P&A agency is this is a network of independent law firms established by Congress to advance the civil rights of people with disabilities. And this really dates back to the 1960s and 70s, when many people with disabilities were in segregated settings. And Congress felt it was important for there to be an independent agency to monitor the conditions in which people with disabilities were being kept or resided. And so P&As, their work really centered on reviewing the conditions in facilities. But as we have moved away from that as a model and have integrated people with disabilities more into the daily fabric of our lives, P&A's work has also grown. And we have found that during our time in working towards the full integration of people with disabilities, that the number one barrier to people leaving institutional settings like nursing homes or residential homes is affordable and accessible housing. So that is why we have a particular interest in housing and housing rights for people with disabilities. Today's presentation really centers around the fair housing rights of people with disabilities, particularly affirmative obligations by housing providers to provide reasonable accommodations. So that's a little bit about who I am and what I'll be presenting on. But Lakeisha, would you like to introduce yourself?
Good morning, everyone. I am Lakeisha Vaughn from Department of Housing and Community Development. I am going to just be touching on the reasonable accommodation process for persons with disabilities as well.
Great. Uh-oh. I believe Lakeisha is frozen. So I'll go ahead and jump in. So today we're going to be presenting on here's sort of the roadmap for today. We're going to talk briefly about the laws that protect the rights of people with disabilities, different types of housing, and what rights may be specific to the different types of housing. Some practical advice related to reasonable accommodations and modifications. How can you prepare those to be effective? And then we're going to be talking about some common scenarios and how what it may be best practices in addressing those. And then finally, we'll do a little application of hopefully what you have picked up from this training. Okay. So we'll start off with just a brief summary of the law. You may know that the Fair Housing Act and other civil rights statutes for people with disabilities identify people with disabilities as a protected class. And what that means is they are protected from discrimination in housing. And there's some context there. The reason of that is because of the historical segregation that we have, that I touched on earlier, about where people with disabilities were previously residing. And I think another, thing that sort of comes to mind is some of us may be too young to remember this, but at certain points, there were similar signs up about no blind people, no people who are deaf, no wheelchair users, independent living requirements. Those sort of advertisements and statements were common in the housing market. So that is why we have laws that protect people with disabilities in housing. And what we know, and I think the COVID pandemic has really highlighted this, which is when people are safely housed as opposed to folks who are in more congregate and segregated settings. They have better health outcomes. They have a better quality of life. So this is an important issue for folks with disabilities. Everyone needs a home, and people with disabilities are no different. Then I think there's some additional information on fair housing on the next slide. So disability is by and far the most common complaint, the most common housing discrimination complaint received by the United States Department of Housing and Urban Development. So you see it makes up 60% of all FHA complaints. Okay, I'm going to go to the next slide. So we're going to talk about a couple of different laws, but really there are some key points about these pieces of legislation that are all pretty similar. The first is who is a person with a disability. And the Fair Housing Act amendments and the Americans with Disabilities Act define it all a little similarly. Can we go back to the slide with the definition? So a person with a disability is someone who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such an impairment. So really that first definition, any person who has a physical or mental impairment that substantially limits one or more major life activities, is really the definition that you'll be working with most regularly. So some of this may be readily apparent. So for example, someone who uses a wheelchair, that would be a person with a disability because they are substantially limited in their ability to walk. Some of it may be not apparent. An invisible disability like a mental health impairment. So it all sort of depends, and it's very individualized. there's a note here that says that just because someone receives Social Security benefits or does not receive Social Security benefits, that does not mean they qualify as a person with a disability under the Fair Housing Act amendments. And so that can work both ways, which is just because you receive SSA benefits doesn't mean you're a person with a disability under the Fair Housing Act, although you're more likely to. And just because you don't doesn't mean you're not a person with a disability under the Fair Housing Act. So we talked a little bit about apparent disabilities and invisible disabilities. So one of the things that you may encounter is landlords requesting records or verification of disability. Really, this is for invisible disabilities, not for the disabilities that are apparent. So for example, if someone is using a wheelchair and they request a wheelchair accessible unit, it's not really necessary or needed, and in fact, maybe illegal for a landlord to request, prove to me that you need an accessible unit because it's so obvious that the person uses a wheelchair. But for those invisible disabilities, it may be more relevant. Okay. And so we've lost our PowerPoint. So we're going to try to keep going. Christina, can you put the PowerPoint back up?
Yeah, I'm working on that right now.
Okay, thank you.
Sorry about that.
All right, well, Christina's working on that. I see there's a question that is asked in the chat, and it says, what proof are landlords usually asking for? So I think this depends. So I think maybe we can start with something people are familiar with, which is an emotional support animal. So what the landlord is entitled to ask for is verification of the disability. And this can be as simple as someone who, a treatment professional, doesn't have to be a doctor. It could just be someone who's familiar with the person's impairment and how it impacts their life. It can be simple as simple of a letter as, X person has a mental impairment. It affects the following major life activity. Describe the activity. And we'll talk about this later, but there needs to be a connection between the disability and the requested accommodation. So that is typically sufficient to verify that the person is a person with a disability under the Fair Housing Act. And there's another quick note here that says the Fair Housing Act amendments exempts those who are current addiction to illegal drugs. So that in and of itself is not a disability. But I think as we have learned more about addiction, we know that there's usually more that goes on with someone who is struggling with addiction. And there may be a mental impairment that can be accommodated. But the issue of current illegal drug use is a hard one, so we'll save that for latest. All right, and I see there's another question about a complex requesting specific forms signed by doctors and approved by corporate for emotional support animal. Is all of this necessary? The short answer to that is no. there's not a required form that has to be filled out. There's not a required process. That isn't to say that a landlord can't have a process. They certainly don't need necessarily a doctor to complete a form. It can be any treating professional who is familiar with the disability or not. And so we're going to move on to the next slide in the interest of time. Okay, so can we just go back to the previous slide, Christina? Or I'm sorry. Oh, you're okay. I think we're good. Sorry, next slide. Okay, so we've been talking about who is a person with a disability. So we're talking about emotional support animals. And what we're really talking about, just to give it a name, is a reasonable accommodation. And this is a right that people with disabilities have under all of those statutes that we've been talking about, or the Fair Housing Act and other civil rights statutes for people with disabilities. And these statutes affirmatively recognize that housing providers have an obligation to provide accommodations to people. And a reasonable accommodation is defined as this: it's a change in rules, policies, practices, or services that would give a person with a disability equal opportunity to use and enjoy a dwelling unit. And that can apply at all stages of the tenancy, from application to occupancy, and even to eviction or even early termination of the lease. So this is an important right. And I think it goes back to the fundamental aspect of disability, which is people are the same. People want to be treated equally, but people with disabilities have different needs. And to ensure equality, those needs are to be met through an accommodation process. Okay, can we go to the next slide? And just to put a finer point on it, failure to provide reasonable accommodations is housing discrimination. Okay, so when a landlord fails to provide accommodations, when a landlord fails to affirmatively address the needs of a person with a disability, that is discrimination. Okay, and these accommodations are intended to be made when necessary to ensure that equal opportunity. So there are some examples there. You know, we've talked about emotional support animals. We've talked about different services to prevent an eviction. We've talked about accommodations at the application stage. So there's a broad range of accommodations that are possible. And really, they are supposed to be individualized to the individual's needs. And when we talk about needs, I think that's where we're talking about that nexus between what the person's disability is and the features of that disability, and what accommodation would allow them to have equal opportunity and use to housing. So it's very individualized. And I think that's where that verification and working closely with the treatment provider can be very beneficial. Okay, so let's go to the next slide. Okay, so we've talked about reasonable accommodations and as a change in policies, procedures, etc. A distinction that comes up in housing is the difference between a reasonable accommodation and a reasonable modification. An accommodation is the change in policy, rules, procedures. A modification is a physical change in the structure. So installing a ramp, adding grab bars, widening doorways, those are all examples of reasonable modifications. And the Fair Housing Act does draw a distinction that we'll talk about later between accommodations and modifications. So I just wanted people to be aware of that. I think what we're really going to try to focus on today is the accommodations, but let's go ahead and talk through some modifications. Okay. So modifications under the Fair Housing Act, that means those structural changes to a dwelling unit. A landlord has to allow a tenant to make modifications to a unit if needed to address the features of a tenant's disability. So for example, someone is using a wheelchair, they rent a home that has a step up, and then they say, well, you know what, I think I need to install a ramp there. The landlord cannot deny the tenant the opportunity to install that ramp, but the landlord does not have to pay for the ramp. Okay. So there are some exceptions to this, such as if there's federal funding involved, or if the housing unit was already supposed to comply with certain design and construction standards. But for the most part, modifications are the responsibility of the tenant. Some other examples where this might come up, we're talking about tenants, but really it applies to any housing. Something we frequently see is homeowners in some dispute with their HOAs or their condominium associations around modifications that they need to make to their homes. And those homeowners associations or condominium boards may not understand that they have an obligation to allow for those modifications, despite what their bylaws and charter may say. Okay, so we want to go to the next slide. Okay, before we go on, I just want to address Daniel's question about how do we find out if a development fits the exception in needing to pay for reasonable modifications. So maybe I can invite Lakeisha to chime in on this, because I think many of the developments where a landlord would be required to pay for a modification, maybe within DHCD's portfolio. So Lakeisha, you want to maybe answer Daniel's question? I know she's having some.
Yeah, she's having some computer issues.
Okay.
So I'm not sure if I'm looking to see if maybe she can type the answer to me and I can answer. So if you want to keep going, I will send her the message direct, or the question directly, and see if she can
Sure.
answer for us.
Okay,
I'm also sorry,
Oh.
I'm on the call
Oh.
too.
Hey, Chelsea.
Hey, so I can answer this question. How do we find out if the development fits the exception in needing to pay for reasonable modifications? So there are some, I'm going to say like general databases that will give you information on how properties are financed statewide and whether they receive low-income housing tax credits. Daniel, we can provide that as supplementary information as a send out after the webinar. I'll try to find the link to that database in the meantime, you know, while David is going through some of the slides, so I'll put that in the chat. Okay. All right. You're welcome.
Okay, so we've talked about modifications and accommodations, and these are all concepts that are embedded in civil rights statutes protecting people with disabilities. And just to give you what those statutes are, there is the Federal Fair Housing Act, which we've been talking a lot about, Maryland's Fair Housing Act, which is substantially similar to the Federal Fair Housing Act. There is the Maryland Accessibility Code related to accessibility features that residential complexes may have. Section 504, Daniel, to your question, this is the statute that protects tenants in properties that have received federal financial assistance, and Chelsea is going to work on getting you some of those databases where you might be able to look at. And then finally, Title II of the Americans with Disabilities Act. And this is worth saying, I think, which is really any state or local government program that provides housing is going to be covered by the Americans with Disabilities Act. So that includes public housing authorities, or if there's another state or local program that would provide actual housing. Okay, let's go to the next slide. Okay, so the Federal Fair Housing Act is really the legislation that covers the most amount of housing, because what Congress really wanted to do was address discrimination in the housing market. It was the Fair Housing Act passed in 1968 in the wake of Dr. King's assassination. And Congress saw that as a response to some of the demands that were coming from people following that event. And so pretty much every participant in the housing market is covered. Lenders, homeowner or real estate brokers, homeowners associations, condominiums, landlords, appraisers. So pretty much anyone who participates in the housing market is going to be covered by the Federal Fair Housing Act. And, we've talked a lot about reasonable accommodations because that's what this training is about. But it also, the Federal Fair Housing Act has other protections as well, prohibiting people from, or protecting people from disparate treatment. So again, it's just those signs that used to be prevalent about no people with disabilities. That is discrimination prohibited by the Fair Housing Act. It also prohibits policies that have disparate impact on people with disabilities. So something may be facially neutral, but in the application of that rule, there may be a disparate impact on a protected class under the Fair Housing Act. That's a little complicated. We're not here to talk about all of that, but one of the things, again, under the Fair Housing Act that is explicitly acknowledged and landlords have an affirmative duty to do is adjust their policies and procedures to ensure equal access. All right, well, let's go to the next slide. All right, there are some exemptions under the Fair Housing Act. Single family housing sold or rented without the use of a real estate broker. So that is essentially someone putting a sign up in their front yard saying for sale, just like the picture says. the housing operated by organizations and private clubs. That is something I've never seen in 10 years. It may be out there, but I think that's a fairly rare exemption. Owner occupied buildings with 4 or fewer units. This is something called the Murphy exception, where I think Congress was concerned about the exposure that people who are renting out rooms or renting out a dwelling unit in their backyard that they may have if that they were not anticipating by attempting to do that. And then sort of missed this one, but the elderly only restricted housing, or HOPA, housing for opportunity or for older persons act, that is a exemption really for discrimination against familial status. Obviously housing for older persons, whether it's for seniors 62 or older or 55 or older, they still have some of the obligations related to, you can't turn away people with disabilities just because they're people with disabilities. You have to make modifications and accommodations. What you don't have to do is rent to people who are below the age limit you've imposed. So those are some of the exceptions. So they're very few. So let's go to the next slide. All right, so again, it's just some of the standard discrimination that you may see in the housing market. Just refusing to sell or rent to someone. Advertising housing as not available to people with disabilities, with sort of independent living requirements. Discrimination in the terms, conditions, or privileges of sale or rental. There's an example there of requiring a co-signer or case manager in order to access housing. Refusing to make accommodations, again, that is discrimination. Refusal to make modifications. And then, of course, coercion and retaliation for the exercise of fair housing rights. Okay. A little bit more about reasonable modifications. I think this slide is talking about the restoration of premises to their original condition. So this is a little bit of some nuance to the Fair Housing Act, which requires landlords to allow a tenant to make modifications at their own expense. There is some right that landlords have to say, okay, but put some money into escrow so that I can return the premises to their original condition once you leave. But that is not required in most instances. It's really, if you're going to make modifications that would impact the way that someone could use and enjoy it in the future, that may be something that they'd want to have an escrow about. They don't have the right to reject your plans for architectural or aesthetic purposes. Really, the only thing they have the right to demand is that it be done in a workmanlike manner. Okay. So here are some examples of modifications. We've talked about ramps, grab bars in the bathrooms, different door handles is a common one, specialized alarms, lowered mailboxes, lowered light switches. Something that we have seen more frequently is in regards to households where a family member may have a disability who has elopement behaviors. And I think this is a pretty hard case. These can be pretty hard cases because frequently what the family wants to do is install double-sided locks, which is typically against the fire code. We don't have any sort of final answer on this issue, but that may be something you encounter, that there needs to be more security in a dwelling because of a family's behaviors associated with a disability. Go to the next slide. So paying for modifications, this is always a challenge, I think, for our clients who are able to pass the threshold of getting a landlord to acknowledge that they do in fact have this right. The next step is actually paying for the modification. So for folks who have vouchers, we've talked about federal financial assistance and that being an exception to modifications. That is not the case for individuals who are renting their unit with a housing choice voucher in a property that is not otherwise receiving federal financial assistance. So if I'm a voucher recipient and I rent a unit, a single family dwelling that's, owned by a management company, a private management company, and I need a modification, then I have the responsibility to pay for that modification. So here are some resources that may be available for folks to pay for modifications. And again, I'll invite Chelsea or Lakeisha to chime in and say more about these resources.
Yeah, sure. I can hop in here, David. So yeah, these are some of the resources that are available to pay for modifications for different accessibility needs that individuals may have. Within some of those local programs, the counties or jurisdictions themselves manage the programs. So the best way to get more information about them is to reach out directly to Baltimore County and Baltimore City. Baltimore City's program, again, it's limited to housing choice voucher participants. So it is more of like a closed loop system. But there are some counties that pay for modification programs using CDBG funding, community development block grant funding. So the best way, again, to determine whether or not a county offers a program like that is to reach out to their Department of Housing and Community Development for the county. The DDA, they do provide some assistance through low intensity support services. Of course, that's specific to DDA funded services. Regarding the Medicaid waivers, so I'm kind of like jumping all over with this slide, but for Medicaid waiver participants, typically the way that modifications are requested is through an environmental assessment that can be done for an individual who has moved into a unit if they need occupational therapy services. So there are limits to the amount of assistance that can be provided through a waiver to make those environmental modifications, but it is a service very typically used for individuals coming out of institutional settings like nursing facilities who receive supports planning services. And again, if the individual you're working with is a waiver participant, that's a service that you can give some more information on. And we did a webinar on that program, so I'm happy to provide a link to that in the chat, so you can get more detailed information on what it pays for, et cetera. The DHCD single family home modification programs, these programs are primarily working in the jurisdictions that DHCD manages, specifically Eastern Shore and Western Maryland. They are able to serve statewide, but again, that's, I'd recommend if your individual that you're serving or working with lives in a specific area, reaching out to the jurisdiction, the DHCD for that jurisdiction, to see what they offer first. The housing rehabilitation program offered through single family, these are typically going to be deferred or forgivable loans that an individual will qualify for. And these are going to be primarily reserved for homeowners. So, I mean, this is not a program typically used for people who are renting. Same with Maryland Whole Home and the Accessible Homes for Seniors program. You can see there's some links there to get more information. But they do provide assistance with home repairs for individuals who are at 80% of the area median and below. And they also provide assistance with getting things like ramps installed or grab bars, things of that nature to make the unit more accessible. We also do have a home modifications directory that MDOD maintains. That directory is managed by our MD TAP program. That program also does provide an opportunity for eligible individuals to apply for loans for assistive technology. And among that assistive technology, somebody could apply for something like a portable ramp or different kinds of technology that could be installed in their unit that helps with making it a little bit more accessible. There are some, credit and income requirements for that program, though. So it's worth, checking out the MD TAP website and reviewing some of that information on their loan program in advance when you're working with someone. So I'll provide some follow-up links for you all in the chat regarding these programs.
Great, thanks. So I see there's a question from Ayana that says, do people with disabilities get insurance like health services with special needs? So I can say that, Medicaid, as Chelsea was saying, the Medicaid program will pay for some environmental modifications. In terms of what other insurance may cover, that would be based on whatever policy someone has. If there's more to be said on that, please follow up with okay, so talk about modifications. Now I want to take us back to accommodations. Again, accommodations are changes in policies, procedures, and rules. Unlike modifications, accommodations are not to be costs are for that, if there are costs, are not to be imposed on a tenant. So let me give you an example. Someone who is blind wants to apply for an apartment and says, hey, I need help filling out the application. If the landlord says, okay, well, we'll help you, but it'll be a $20 charge to do that, then that would be illegal because you're not supposed to charge tenants for the cost of an accommodation. Other common accommodations, parking spaces, someone needs to be close to their unit because of a physical impairment. The construction of an actual parking space is considered an accommodation. And again, there must be that nexus between the disability, and the requested accommodation. Now I think we're going to talk a little bit about how far do those accommodations go. And you see it there at the bottom. It says housing providers must grant accommodations unless it's an undue financial and administrative burden. Okay, so financial and administrative burden. So that is a big inquiry, right? Because so you have to look at the totality of resources available to a landlord and a housing developer. So this could be really hard burden for a developer to meet, especially someone who may have multiple developments and multiple units. So you've got to look at all of the resources they have, and not only must it present an undue financial burden, but it must also be an administrative burden. Okay, so that's a hard threshold for housing developers to satisfy. Another defense is fundamental alteration of the programs and services offered by the housing provider. So I think the classic example that is provided is when a tenant may need a specific form of support or services, and such as a landlord, I can't get out to walk my dog. Is that something you can do? No, that would be a fundamental alteration of what the landlord does, which is offer housing. They don't have the obligation to provide that dog walking service. The example that is given here is around a disposal of trash. I think that's a pretty good explanation in terms of how you would evaluate this. Is it really an undue or fundamental alteration for a large operation to come and pick up trash? Have your maintenance man just walk by the door and do it. And I think that the answer would more likely than not be no. That's not a fundamental alteration. It's not an undue burden. Okay, so some few defenses to accommodation requests: one, undue financial and administrative burden, and fundamental alteration. Last comment on this, which is even if your requested accommodation, if a landlord says, well, that's undue financial burden or a fundamental alteration, they can still have an obligation to offer some alternative accommodation. The last thing I'll say about that is it shouldn't be a conclusory statement by the landlord. If they're contending that what you're asking for is an undue burden and financial burden, prove it. Make them prove it. Show us the money. Show us why you can't do this. Don't just say it. Another common thing that you may encounter with landlords is, well, we don't want to do that exact accommodation, but here's another accommodation that we're comfortable doing. If it's not an undue financial or administrative burden or fundamental alteration, their level of comfort isn't really relevant. So you can insist on the accommodation that you wanted. What they offered may be very appealing to you, and that may be acceptable. But that's part of a process that has to happen. Okay, so before we move on to this next part, I'm just gonna check the questions. Okay, so Tracy asked, if a resident is able to receive a home modification approval to make the home more accessible, what happens if the person gets a non-renewal? That is a good question. So in Maryland, a landlord is not required to renew a lease. Okay, so at the conclusion of a lease term, a landlord can decide, I just don't want to renew your lease. And they don't have to have a reason or good cause to do that. They can just decide to end the lease. Now, there's always a reason. So, if something like that happens, I'd encourage you to find out what the reason is. The reason cannot be a discriminatory one. So if there's something going on where the landlord has a discriminatory reason for wanting to end the lease, that would probably be a violation of the Fair Housing Act. It would be a violation of the Fair Housing Act. If there are other issues, the landlord's just looking to get out of the landlord business, that may be a reason to not renew the lease. So it is an unfortunate situation that can happen where tenants may have expended a lot of time and resources into making a rental property accessible, and the landlord makes a decision to not renew the lease. So it can happen.
Yeah, and I was gonna just chime in there, David. If it depends on if the modifications affect the marketability of the unit, and also what kind of funding the unit has, right? So, if they're living in a property that is not getting federal funding, and they've made these modifications, they've paid for the modifications, right? So the housing provider's not paying for it, then they could be expected to change that, make those modifications back so the unit is, doesn't have those features anymore. So that's something to account for. If you're working with someone who is just renting on the private market, it's something to think about. And there are certain, determinations. I don't want to go into too many specifics here because each situation is a bit different, but if the modifications themselves are considered to impact the marketability of the unit, then it's going to be, more likely that landlord is going to want to have that unit changed back after. It's a little bit different with federally funded units. The expectations are different, I would say, but I'm happy to provide some examples.
Great. And I see Daniel has a follow-up question. No, not really. They're not required to provide an answer. I suspect that, if they're just being obstinate and not providing an answer, there's probably more to be said. And, that may be the time to think about contacting a lawyer. So, but, we'll save that for another discussion. Okay. So we've talked about modifications. We've talked about accommodations. The accessibility. So another thing that the Fair Housing Act requires is that units constructed for first occupancy after March 13th, 1991 satisfy certain design and construction requirements. Any multifamily complex with 4 or more units is covered. All units in an elevator building and ground floor units in non-elevator buildings. So that date right there on March 13th, 1991 is sort of the date at which everything built after that is supposed to comply with these design and construction requirements. It's not the highest accessibility requirements, but it can be very beneficial to folks. And this would be one of those exceptions where if there's something in a unit that doesn't comply with these design and construction requirements and a tenant needs a modification, the tenant doesn't have to pay for the landlord's, failure to adhere to the Fair Housing Act. That's something that the landlord should do. Okay. All right, let's go to the next slide. I think we may have done that slide. We want to go in the other direction. There we go. Okay. So there is the accessibility guidebook for the Fair Housing Act amendments, and I recommend using that for a sense of what the accessibility features that a covered property would have to have. It's pretty technical. The way I typically tell people to approach this is, one, go take a look. Does it look accessible? Does it look like someone with a wheelchair could use it? If not, take some measurements of some things that you could measure, like the width of the doorway, the space in the kitchen, some very simple measurements. And if things are off, maybe that's the time to think about, getting a more professional opinion. Okay. Let's go to the next slide. Okay, so we are now on the Maryland Fair Housing Act. So again, substantially equivalent to the Federal Fair Housing Act. Many of the same protections, or the same protections in the Federal Fair Housing Act are in the state law. There's some additional protected classes under the state Fair Housing Act: sexual orientation, marital status, gender identity, and one that we are missing here is source of income, which is relevant, I think, for a lot of people with disabilities. So source of income would include folks who have housing choice vouchers. It would also include folks who may have like a special needs trust or an ABLE account, or they have someone who pays their rent on their behalf. So any lawful source of income, so long as it can pay the rent, that's really all the landlord should be looking at, not what the source of the income is. Okay, let's go to the next slide. Okay, so we are now talking about Section 504 of the Rehabilitation Act. That is a statute around, it actually predates the ADA and the Federal Fair Housing Act, and it applies only to recipients of federal financial assistance. So it's sort of the granddaddy of our civil rights statutes for people with disabilities. And it provides that no qualified person with a disability shall be excluded or denied benefits or subjected to discrimination because of their disability. So again, some requirements include modifications, accommodations, ensuring access to the program generally, as well as those accessibility rules for construction and alterations. Okay, so what's really important here, I think, is Daniel's question earlier, which is, how do we know what property is covered by Section 504 when we're making these modification requests? And I should just clarify that point. So the reason we're talking about Section 504 is that is the law that creates that exception where if you're in a federally funded housing program, you are not required to pay for modifications to your unit. That is the landlord's responsibility. And that is by virtue of them having a program that must be made accessible to people with disabilities. So these programs include public housing. It includes project-based vouchers. That's when a voucher may be connected to a specific unit. Project-based rental assistance. It may be called in-house HUD Section 8. It may be called HUD multifamily Section 8. So it can be a little confusing, but this is usually privately owned, federally subsidized housing. Home-funded programs. So these are funds that may come through the county development agency, but are actually federal funds that the county development agency administers. Rural development housing, 202 housing, specifically for people who are elderly, and of course Section 811 housing for people with disabilities. And there's a quick note here about low-income housing tax credit properties being covered that were after 2018. But I'll invite Chelsea and Lakeisha to chime in on this point. So does this include modification requests? I understand that tax credit properties have to have meet the UFAS scoping requirement of 5% of their units, but is it your interpretation that they also have to provide modifications to tenants who request those as well?
For tax credit communities, yes. I mean, as long as it doesn't create the undue financial burden on the housing provider, then yeah. And I mean, and it's also an iterative process too. I want to just make sure that folks are aware of that. So, you know, in the event that the original modification request is for some reason considered too burdensome for the housing provider, they are obligated and required to have a conversation with the tenant. So they have to have a discussion about what might work in lieu of the original request. Does that answer the question, David? Or did you need that?
Yeah,
Make sense?
I think that's good to know.
Yeah, and I put HUD's a link to HUD's website on accessibility requirements. It kind of breaks it down based on Section 504, the ADA, and the Fair Housing Act. And I'm just going to put some more supplementary information here in the chat for folks who want to do a little bit more digging on these topics. Lakeisha, did you have anything to add?
Hi, Chelsea. No, I think you pretty much covered it. Yes, they are required to have funds and reserves for those modifications. And of course, as long as it doesn't meet the administrative burden, then yes, they're required to make them.
Okay, so I see there's a question from Jennifer. Maybe Lakeisha could reach out to Jennifer afterwards about participating in some of the programs that we've talked about. Okay, so I'm gonna skip ahead a little bit to Christina, could we go to the interactive process and obligation to affirmatively further fair housing? So as Chelsea was talking about, the accommodations, modifications, should be a non-adversarial process. And I just want to go back to one of the questions we got earlier about, my landlord is making me submit this form that's signed by, a doctor, and then it has to go to corporate. And I think that you know, in some ways that's unfortunate because it really, um, uh, I think there's a lack of confidence, I think, from some of the folks on the ground about addressing these issues with their residents and their tenants and sort of make things a little bit harder. But it should be a non-adversarial process. So, you know, going through that process of getting your doctor's letters and, you know, submitting it to the landlord and having a corporate officer review it, you know, it can feel adversarial, but it's not intended to be. The point is to find a solution to the person's disability related needs. And again, if it's not an undue financial or administrative burden, then the landlord doesn't really have a reason to reject it. And that's there. If there are several possible accommodations, it is up to the tenant about what their choice is. Landlords can always offer different, but the question is whether it's an undue financial and administrative burden. And there should be discussion. If it is a burden or if it is a fundamental alteration, that's really when the opportunity to have more dialogue, more discussion, and more negotiation around what's a good solution to the person's needs. So that's, I just wanted to touch on that and reiterate that point, that it's really problem solving. You know, how do we address this problem that our tenant is facing? Okay. There is an obligation related to affirmative marketing and affirmatively furthering fair housing. You know, what we're talking about is increasing housing choice. You know, what is it that, and this applies particularly for state and local governments, what is it that we're doing to increase housing choice for people with disabilities? And some of those programs that you heard Chelsea talk about, paying for modifications, that's a way to increase housing choice for people with disabilities, creating more options for people in the housing market. And that's really what's at the heart of fair housing, is choice. So I'm trying to think if there's anything else that we want to touch on before maybe getting into some of the more practical advice. So Lakeisha, Chelsea, anything else you guys want to say on just accommodations and Fair Housing Act in general?
One thing I do want to mention, actually, and this is just, you know, very recent, HUD is seeking feedback on Section 504. So I've sent this out to a few individuals, but they have a number of questions regarding how Section 504 applicability has changed, particularly in light of the fact that we've had increasing changes in assistive technology, you know, what housing providers typically provide for a person with a disability. You know, they're asking questions about things like application processes and ways to account for ensuring that housing providers are doing everything that they can under Section 504. So I encourage you all to take a look at that. There's taking comments until the end of July. So just, you know, please take a look, and if your agency wants to submit comments, you're able to do that. I see Candace had mentioned sending the survey. So the survey from the first training, unfortunately, when we got responses back, they were all listed as anonymous. So everyone will get a final quiz after completing all 4 of these modules, and that will be what needs to be done in order to get credit to move on to the next phase in the process if you're doing this for the Tenant Training 101 work. So just keep your eyes peeled for that. Okay, that's all I had to say.
So Chelsea, we have about 14 minutes left. Is that right? Okay. Why don't we jump forward to slide 39, thinking through accommodations and modifications. Okay. Yeah. All right. So I think we're just gonna go through this and give a little practical advice. So as we talked about, accommodations are it's something that must be provided to people with disabilities if needed throughout the tenancy process. Okay, so that can include applications, that can include lease terminations if it's related to something, a feature of the person's disability. So it really is looking at what the person needs and what their housing situation is and what can be changed without fundamentally altering the nature of the housing program. Okay, so let's go to the next slide. So here are some of the common issues that we see. Okay, getting and staying on waiting lists. Okay, so this may be something you have experienced, which is someone applies to a waiting list and then, time passes, they never hear anything. The next thing they hear is that they've been removed. And this can happen for a lot of reasons. It may be because they don't have an opportunity to comprehend the mail that they are receiving related to staying on the waiting list. It can also be that they may have had to move because of a situation with their housing. I think also some issues with getting on the waiting list may relate to criminal records of people with disabilities. So if there's a criminal record and it relates to someone's disability, then there may be an accommodation that is available, such as adjusting that screening criteria to get the person on the waiting list. Some other common issues include missing documents. So I think, again, this is a good opportunity to engage in an interactive discussion with a housing provider, which is a housing provider said, well, we need all this identification. We don't have it. What is it you really need and what could we substitute for it? So I think there's an opportunity there. Deadlines, credit issues, criminal background issues. So all of these issues, I think there's an opportunity to think about what your specific client situation is. How is it related to the person's disability? And can we change some of these barriers that exist to allow folks to access housing? Okay, let's go to the next slide. So here are some possible accommodations. Someone with a vision impairment, providing application material and an alternative feedback. Someone who may have a learning disability, who can't read the application. A landlord could provide assistance in completing the application. Allowing a secondary contact person. This is something we frequently have. I think sometimes it's helpful for people to have that intermediary with their landlord, especially if things may be a little tense. So we found that to be helpful. Additional time. This is particularly relevant for folks who have vouchers and need additional time to find housing that is suitable for them. Home visits, that is something that we frequently ask for, particularly around document collection and things like that. Again, just an opportunity to think creatively and collaboratively with your client about, what are their disability related needs and what can we do to actually get folks housed. Okay, next slide. It's just a couple more examples, particularly around credit issues. Someone who hasn't participated in the workforce, maybe that credit screening creates too high of a barrier, and they haven't participated in the workforce because of their disability. Does that waiver of that credit requirement really constitute a fundamental alteration? I would say if there are other records that demonstrate that a client can pay their bills and has paid their bills, that is evidence that maybe some of these other credit issues can be ameliorated, or we can get over this barrier that is being imposed. Okay. So again, just some of the issues we've talked about, overlooking poor credit history, consideration of individual circumstances related to criminal background screening, extra time to gather documents. So why don't we go to the next slide? Yeah, so just a little bit more detail on the criminal background issues. And so this may be something that comes up for folks who may have a history of substance abuse disorders. And I should say this, we talked about people who are currently using illegal drugs as not being protected under these statutes, but folks who are in recovery are protected. That is considered a disability for purposes of these statutes. So folks who are actively in recovery, if that's their disability, then they are covered. And so you may get this frequently where someone who's trying to access housing is told, well, you've got this criminal record, going back 5 years. And so therefore, you're going to be excluded. But, are you able to demonstrate that despite that criminal record, there is that the person is still going to be able to comply with the terms of the housing because of, completion of some rehabilitation programs, the passage of time, some evidence that they've taken the steps to ensure that this sort of behavior won't happen again. So those are sort of issues that you can get into. Again, very individualized, very specific to the individual. There are sort of two complete exemptions related to sex offender registry and production or sale of methamphetamine on federally assisted properties. I would say that those are pretty rare situations, at least in what I've encountered. All right. Okay, so there is some specific guidance around criminal background checks. So HUD has said that a record alone is typically not sufficient to knock someone out for criminal background check. And what I mean by a record is let's say a landlord is screening and says, oh, you were arrested for, CDS possession. Therefore, you fail our criminal background screening. And what HUD has said is an arrest alone and a record alone is not sufficient to deny someone access to housing. But we also have to get into what actually happened and whether there is a more individualized inquiry we can do to determine whether the person, whether this record really presents the barrier that our policies say they do. So that's something to be aware of, is arrest records alone are generally not going to be adequate to knock someone out completely. Okay, so some accommodations in housing. Assistance animals, we've talked about that, care attendants, live-in aides, all of these issues I think are hopefully familiar. And again, just providing that documentation of the disability related need and the connection to the accommodation. Can we skip forward to, because I think we want to talk about it generally. Yes, threatening behavior and reasonable accommodations to prevent eviction. Okay, so this is something that may frequently come up, which is your tenant may receive an eviction notice based on some breach of the lease. If the breach is connected to someone's disability, then an accommodation may be possible. But I think what you would have to show is that the breach is not going to happen again, or is going to be unlikely to happen again. And that may look like different things. So it may be the tenant has been counseled about their behaviors. It may be that the tenant is getting different services and supports. So it's very individualized, and think about what interventions may be possible to avoid really a crisis in housing. And even if there is an issue of a direct threat, right? So a tenant's disability, they may have gotten into a physical altercation with someone. Even if that exists, a landlord still has the responsibility to consider accommodations that are not fundamental alterations. So if the accommodation is, let him keep living here, or let this tenant keep living there, even though he's gotten into fights and he's not receiving anything differently, and he's going to keep doing that, that's really a fundamental alteration. But if there's something you can say that would demonstrate, hey, these behaviors are going to stop, or they're going to be ameliorated in some way, then I think that would be the kind of accommodation that landlords are required to consider. Okay. All right. Well, I see we're at 11:30, so I'm going to zip it. And I think this slideshow will be available for everyone. Of course, if there are any questions, I'm happy to stay on a little bit longer and answer questions.
Do you want to take a few minutes for any other questions that might come up?
Yeah, for sure.
So if anyone has a question, go ahead and select raise your hand and I will unmute you so you can speak.
I just wanted, I see Camille had a question, just really quick. Yes, you will receive the PowerPoint. We are aware that we did not send out the one for Monday. Just keep in mind, it's just me and Christina really trying to organize this with Lakeisha supporting us as well. So you will receive it if you registered and attended Monday's session. And we can take a question from Camille. Let's see, let me ask to unmute you, Camille, I think. Okay.
Can you hear me now?
Yes.
Yes.
Okay,
Mhm.
if a landlord or property already have it in their lease and guidelines that they do not accept pets. Okay, if a person has a pet, it's not considered discrimination, is it? If the landlord says no, if they don't allow everybody, across the board not to have a pet, it's not discrimination, correct?
Emotional support animals and service animals are not pets. Emotional support animals and service animals are considered accommodations under the Fair Housing Act. So I think what would be required of the tenant is to demonstrate that, one, they are a person with a disability. Two, that it's substantially, and two, that they need an emotional support animal or service animal to allow them to have equal access and opportunity to the dwelling.
Okay, I know pretty much the service animals usually have like the harness and everything, or on their back to show that they're a service animal.
Mhm.
However, with the companion one, that's been hard to prove.
So there is not a specific training
Okay.
that an emotional support animal has to do. The only thing that is required is that a tenant needs it to address a feature of their disability. And a landlord can request verification of that from a treatment professional. But they cannot deny a person with a disability the right to have an emotional support animal. And so even if there is a no pets policy
Mhm.
or a charge associated with pets, none of those would apply to an emotional support animal because they
Okay.
are not considered pets.
Okay. Okay. For pet. Okay, thank you.
Mhm.
Does anyone else have a question?
Tiara put a link in the chat for a great site on emotional support animals. So thanks for sharing that link, Tiara. I think we should be ready to wrap up if there aren't any further questions.
All right. So thank you, David, for presenting today. We appreciate you with your presentation. Thank you, Lakeisha and Chelsea, for your assistance as well. Just a reminder, our 4th training is scheduled for Monday. And that one is I was going to call it emergency preparedness. That's at 10 a.m. So if you're not already registered, make sure that you go in and register for that 4th training as well, so that you get that registration link and can complete Tenant Training 101, the training curriculum. If you guys have any questions after we end the call, please feel free to send myself an email or Chelsea. And if we don't know the answer, we will get that answered for you and respond. But again, thank you everyone for attending. And again, thanks to David and Lakeisha and Chelsea for presenting.
No
I hope
problem.
everybody
And
enjoys the rest of your day.
quick note, everyone, just put the registration link for Monday's training in the chat. So go ahead and sign up if you haven't already. Okay.
Great. Thank you.
Thanks, everyone.